Our next file is People of the State of Michigan versus James Swiderski. This file number is 24-3551FH. Appearances, please.
Thank you, Your Honor. David Denhausen on behalf of the people.
Robert Hartzell from Mr. Swiderski, who joins me to my left.
All right, thank you. Ms. Laura, you may be seated, gentlemen. Ms. Laura Odell is here from the Michigan Department of Corrections, serving as a probation officer today. We are here today for a probation violation hearing. And we were last on the record, looks like back early in February. Looks like that was February 3rd for the first, and then we came back on February 6th. And then it looks like the parties waived their 14-day right. And now we're here. All right, so what are we doing today, Mr. Hartel?
Yes, Your Honor. I do believe there's going to be a resolution where my client will give a factual basis in exchange for the people agreeing not to oppose a release to treatment if the court were willing to grant it. We realize that's not a Killebrew agreement. And when the time comes, I do have some additional proofs to show the court for that, but we do anticipate that, yes, Your Honor.
Okay. Mr. Denham?
Yes, Your Honor. It's my understanding that it would be a plea to two technical violations. There are two separate instances where the defendant drank and had alcohol. That's why it would be the two technical. So there is that exposure, which is fairly limited, but as has been discussed, the defendant was previously released early for treatment, so he didn't serve the initial sentence. So there's that that could potentially be ordered, but we would not have any objection to the defendant at the discretion of the probation department being released to treatment.
So let's take a look at this. Mr. Denham has mentioned two technicals. I know there are four technicals alleged, and it's my opinion that while there are four listed, two deal with the same series or transaction of events on December 5th, therefore I have to treat them as one, and then two occurred on December 15th. For instance, you can't consume alcohol without possessing it. So in my opinion, if he enters a plea of guilty to all four, it really will only count as two technicals. Does that make sense, gentlemen?
Yes, Your Honor.
Yes, sir.
Okay, all right. Mr. Swiderski, is that how you wish to resolve this?
Yes, sir.
Thank you. I do know we have a couple of witnesses joining us today. Folks, just stay there until I say you can go, until I accept the plea. Mr. Swiderski, please raise your right hand. Do you swear or affirm that the information and testimony that you're about to provide shall be the truth, the whole truth, nothing but the truth?
Yes, sir.
You may lower your hand. Mr. Swiderski, when these events allegedly occurred back in December, were you on probation or parole anywhere else other than this court?
No, sir.
You again have the right to have a contested hearing and make the prosecutor prove the allegations by preponderance of the evidence. You have the right to question or cross-examine any witness presented against you at that formal hearing, as well as the right to present witnesses, evidence, or testimony if you chose, as well as the right to remain silent and not have that silence used against you. Do you understand?
Yes, sir.
Now, if you enter a plea of guilty to these four counts, you will not have that hearing and you'll be waiving those rights. Do you understand?
Yes, sir.
Other than that kind of a discussion we heard about the prosecutor not opposing a release treatment, have there been any other promises, threats, or inducements to force or compel you to plead guilty to these?
No, sir.
Are you entering the plea of your own free choice?
Yes.
Have you spoken about the allegations and your rights and options here with Mr. Hartel?
Yes, I have.
And was he able to answer your questions?
Yes, sir.
And are you satisfied with his advice?
Yes.
And do you believe that proceeding today, as we discussed, is in your best interest?
Yes, sir.
Thank you. All right, as to the four allegations that I discussed earlier, how do you plead?
Guilty.
Before the court can accept that plea, I'm going to ask you some questions. However, before I do that, I take judicial notice of the terms and conditions of probation that are a part of this court file. They were signed by me on or about March 18th of 2025 and acknowledged by the defendant on March 21st, 2025. Mr. Swiderski, looking back in December of this past year on 2 days, on December 5th, and then 10 days later on December 15th. Did you consume, possess, and/or consume alcohol?
Yes, sir, I did.
All right, and what was it that you consumed?
Beers.
All right, and you knew that it was a violation of your terms and conditions of your probation?
Yes, sir.
All right. Mr. Denhout, do you believe you provided a factual basis?
I do, Your Honor.
Are you aware of any other promises for inducement?
No, Your Honor.
And you believe the court's complies with court rules?
Yes, sir.
Mr. Hartel, do you agree?
I do agree, Your Honor.
The court agrees and finds the defendant's pleas today are made freely, knowingly, and voluntarily. The court specifically finds the testimony provided by the defendant under oath on the record, in addition to the digital notice of the terms and conditions, satisfy the elements. Therefore, the defendant is found guilty of all 4 counts, and for all tracking purposes, they're only considered as 2 technicals because counts 1 and 2 are of the same series of transaction of events, and counts 3 and 4 are treated in the same manner. All right, are we, gentlemen, we're on Zoom. Deputy Stickler and Mr. Chandler from the Department of Corrections, you are free to go. Thank you very much for your time. You're released.
Thank you.
Thank you. All right, are we able then to proceed to sentencing, Mr. Denhout?
I believe so, Your Honor.
Mr. Hartel,
Yes.
back to you, Ms. Odell.
Your Honor, Mr. Swiderski, these events happened back in December of last year, a few months ago. What's somewhat concerning to me is that both times Agent Chandler went to Mr. Swiderski's house, found him to have cans of beer, cans of alcohol at the house, along with testing positive for alcohol. Both times, Mr. Swiderski stated that he was looking into detox and residential treatment, and that he had a bed available, and that he would be entering into treatment soon. And that was in December. Here we are, February, and he still has not done that. I am glad to see that he's now at the last minute taking steps to get a residential bed, and I have absolutely no problem with him entering back into residential treatment, but it just is somewhat disappointing that he drug his feet for 2 months before that happened. Your Honor, originally sentenced Mr. Swiderski to 150 days jail. He was released early to attend treatment, so at this time he has 94 days of credit. I would recommend that Your Honor impose the 30 days allowed for 2 technical violations and sentence him to 180 days jail with 94 days of credit.
Thank you. Mr. Denhout?
Your Honor, I'll be brief. I support that recommendation, Your Honor.
Hold on. Mr. Hartel.
Yes, thank you, Your Honor. Just so the court is aware, there was some reference to a letter from Addiction Treatment Services. If I may proceed with court copy.
Thank you. I have that letter.
I would ask the court to consider allowing my client to go to that treatment. I realize the court may feel more comfortable having a bit of a sword dangling above his head, perhaps with a sentence where if he doesn't complete it properly, then he has to report to the Misaki County Jail and serve perhaps even the recommended sentence that was noted by the people in the probation department. However, I do believe it would benefit him. I do believe this is a case where these violations were due to his addiction. There's no way around that, to be frank. If it wasn't for a demon on your back, why would you intentionally allow yourself to do things when you know you're being monitored? You know you're going to get caught. No intelligent person is going to do that unless they know there's a demon they need to get off their back. And maybe he's flirted with this idea a little bit in the past, but he's definitely dedicated to it now. And I would ask the court to give him that opportunity. For additional information, just so the court's aware, he does have moral support in the courtroom, both his employer and his employer's spouse. I do believe they'd help in any way they could, perhaps even transporting him to and from. They do want him to get better so that they can keep him as a long-term employee. They do consider him not just an employee, but a friend, and they do want to see him do well in life beyond just the scope of their employment. I just would ask the court to consider that. Thank you.
All right, thank you. Mr. Swiderski, you have the right to make a statement. Is there anything you wish to say today, sir?
I was wrong. I was in the wrong. I consumed alcohol. I possessed it. Apologize to the courts. I wish to be released to go to Petoskey Hall
Okay.
and do the long-term 90-day program that they have there.
Thank you. Well, I greatly appreciate and support the Addiction Treatment Services mission up in Traverse City, their efforts to reach down to or out to other surrounding counties, even rural counties, is quite commendable. The court, however, is quite concerned here about the defendant's behavior. You never need to apologize to the court. I'm here Monday through Friday. So you don't need to apologize to me. It's my job. And despite what some people may perceive, the job up here as a judge isn't always about punishment. These are opportunities to help people figure out their lives and correct their issues and get treatment when they can. Sometimes jail is necessary, certainly, but or confinement in prison even if necessary. Now, what were his guideline ranges, Ms. Sodell?
0 to 17, Your Honor.
So that tells me you have some prior criminal history. So that's a bit concerning. Well, the court's going to file the recommendations here of everybody added together. The court continues probation as previously set by this court. The court preserves any unpaid fines and costs. The court sentences the defendant to 180 days in the Missaukee County Jail with 94 days of credit. And if the defense is able to get a confirmation as to a delivery, or I'm sorry, an open bed date, then coordinate that with Ms. Odell, and I'll grant that and sign an amendment. But we're going to send Mr. Swiderski in the back here today. But if the defense gets to Ms. Odell a letter saying, yep, we'll take him tomorrow or whatever, I will sign the modification of the bond.
Just so the court's aware, my clients advised me he believes they would take him as early as tomorrow. I realize that's not in the letter that we showed the court.
Well, it's only 3 o'clock. Somebody figure that out, okay? And I'm telling you right now, I'll go ahead and approve it. So as long as you get confirmation, Ms. Odell. But I'm going to start here from the jail, right? And he'll be picked up by Wex Express. I appreciate the friends who might be willing to drive him, but we have an agreement, we mean the court, with the Wex Express. It picks people up straight from the jail, drives them to the program, and then drives them back. There's a reason why we do this. Not that I don't trust you folks, but sometimes people like to get a little sip in before they get to the treatment program. And I don't want that to happen. I don't think that's good for Mr. Swiderski in his attempts here to maintain sobriety. If you're able to get that from them even to this afternoon, Mr. Hartel, I'll take it and sign it. Okay. Let me know if you have any difficulty getting a hold of them. I've got most of their cell phone numbers on my phone. All right, thank you very much. Mr. Swiderski, Mr. Hartel is going to provide you 2 copies of one document. One of them you're going to place your initials on. The other one you're going to take with you. When you place your initials on one copy, you are neither electing nor waiving any rights. You are merely acknowledging your receipt of your copy of that document. This document tells you that you have the right to appeal the conviction and sentence in your case. And based upon the plea in this case, any appeal will be done by filing an application for leave to appeal. If you choose to file an application for leave to appeal and you want the court to consider appointing an attorney to assist you, you may complete the bottom half of the document and return to the court within 42 days. If you choose not to appeal, you may simply dispose of your copy of the document. I don't want to keep talking because I want to make sure Mr. Hartel can get on the phone. Yes, ma'am.
Your Honor, just wanted to clarify, if you would like Wex Express to transport, that would not be facilitated today, correct?
Correct, but it can be done by
But we
Monday.
get a date.
Yeah.
Okay,
Yeah,
thank you.
I don't care. That's fine. All right, anything else, Mr. Denham? Thank you very much, sir. Mr. Hartel?
Nothing else right now, no, Your Honor.
All right, Mr. Swiderski, you gotta have a little bit of a hammer here, but I want to get you in this treatment. We want to be positive and help you change the direction of your life. How old are you? 50. All right, well, 50 is a pretty good time to start. You know, acting smarter. So I'm 54. I think hopefully I figured it out. I don't know.
So how many days do I have, Your Honor?
You have 180 minus 30 for good conduct time. It takes it down to 50. And then you had 90 some days of credit. It was 94. So
Yeah,
you would have 56 days left to serve. However, if you're able to get into a bed within the next week, I'm going to sign it and send you there. Right? So we'll get you out earlier. Okay, but now here's a little highlight. If you violate probation again, and you have to come back, we don't want to be negative. You still would have the remainder of that 50 some days to serve, plus whatever you'd get on another probation violation. So even if it's a technical violation, it would be 45, it could be 45 days plus whatever's remaining from this 56. That's without batting an eye. All right. Thank you very much. I acknowledge receipt to return to that document and place it in the file. We are adjourned. You're going to go off with the detection. Thank you. All right.
Taking the pre-trials early for the detective to know? Or
Yeah.
Are you
Yeah.
half an hour early?
Well, but I've also, I haven't got you the form yet, have I? Great. So for pre-trials, I've got 2 pleas, 3 pre-trials.